and allows the critical access hospital governing body the option of choosing to rely on the information provided per the agreement that has been approved by and reviewed and approved by their medical staff and making the governing body making the privileging decisions. Let me go ahead to the next slide. We also propose to amend the periodic evaluation and quality assurance review COP to add an additional entity that can do the peer review and, let's see, I have to read this. The critical access hospital COPs right now identify 3 different entities that can do quality assurance and peer review and credentialing and privileging for them. It's the QIOs, another QIO entity, or another larger facility within a hospital state. We're a plan, a network hospital. We added the distance site hospital that's providing telemedicine to an entity that can do credentialing, privileging, and peer review for the telemedicine providers. So this requirement is in addition to the other 3 that's already allowed to perform that function. There's something else I wanted to say in relation to this. I'm trying to remember what it was. It'll probably come to me in a minute. You can go to the next slide, Greg. So again, proposed rule was published on May 26th. We wanted to reduce burden and eliminate the duplicative credentialing and privileging process. And it is a result of the outreach efforts. And I will tell you that if it wasn't for people like Greg and Karen and several other people in the telehealth community, we would not have been aware of the significant impact that this telemedicine rule or regulations as they stood was going to have on the community. And it was from their diligence and persistence that they got through to the right people. And that's how we got to where we are now. And again, I will remind you the comment period ends on July 26th. And by law, actually, we need the comments before the dead date, the due date, because July 26th is the drop dead date. Comments after that have to take into special consideration. So please get comments into us before July 26th. And I hope that wasn't too rattled for you all. I'm very open for questions, and I hope the information has been helpful to you.
Thank you very much, Jeannie. I appreciate very much, and you've put some good information to the table. We already have questions coming in. Let me remind the audience that your questions can be submitted through the Q&A feature there on the live meeting client on your box, and then I will propose them to Jeannie or Dr. Ruban. I don't know how this how the sound came across in the audience with the audience, but I think we are in downtown Washington D.C. and I think at the time you were describing what comes next after the deadline for the proposed rule concludes. I think President Obama must have been moving on the street. Because I don't know if you were able to come through or not, but there was a lot of sirens and they weren't the normal ambulance sirens, so I think somebody was moving with a motorcade. Would you mind taking a second and just recapping that again about, okay, July 26th comes, you've got all your rules and you've got all your comments in on the proposed rule. What happens next?
Okay, and before I do that, I want to go back and talk what I remembered I wanted to mention. What I did not talk about is that the distant site hospital that's providing the telemedicine services actually would be able to provide the smaller facility with a list of the practitioners that would be providing services to telemedicine, of their license and the privileges that they have been granted, so forth, that the medical staff of the smaller facility could use to review and then make recommendations to the governing body. I wanted to make sure that I mentioned that to people. Yes, we will, when we get all the comments on July 26th, we then sit down and go through all of them and summarize all of them and respond to all of them. And depending on how the comments are laid out and the recommendations, We then will make revisions, write a final rule which will include all the comments and our responses and any revisions we made and the rationale behind all those revisions. It will then go through our clearance process at CMS. It will be signed by our administrator. It will move to the Department of Health and Human Services, to the Secretary. It will be vetted through all the different agencies within HHS, such as CDC, ask for all the different agencies within CMS or HHS have an opportunity to comment. It goes to OMB, who has final approval, Office of Management and Budget. And then it will come out as a final rule in the Federal Register. The effective date will depend on what kind of comments and things we get on the proposed rule. It can be anywhere, effective date, the day of publication, 30-day effective date, 60-day effective date. We plan to move it as quickly as we can. As I said, it takes usually 2 to 3 years to get a regulation through, but we hope to have it published as a final rule prior to March. I cannot guarantee that will occur, but that is our hope.
Right. And if I could
just, looking for, Greg?
And yeah, exactly. And if I could just add one fill in around that, in the conversations that Dr. Ruban had with CMS in driving home this point, and others at the table, there were two issues that were put in front of CMS, and they responded to both of them. The first issue being there was this July 15th deadline, and it was critical that something happened to stop the train going down the track towards this July 15th deadline, and that was accomplished by the letter and the extension to March 1st of 2011. And then the second item that was put on the table was, in fact, the need to have a longer-term look at the policy and revisions in the policy, and CMS responded by this rule. Anything you'd like to add to that, Dr. Ruban?
Well, the one thing I would like to remind people is it behooves us to provide CMS with the comments, because when the final rule is published, it's likely not to be relooked at again for quite some time. Wouldn't that be correct, Jeannie?
Absolutely.
And it's a very onerous process. I myself, quite frankly, did not realize all the implications, all the statutory elements of a rule change. It's gigantic, and looking at all the different federal agencies that have to weigh in on these rule changes. So, again, please accept our sincerest gratitude for expediting this as you have.
Okay.
It's been very important, very near and dear to my heart to move this, as you both know.
A question from the audience. The proposed new standards allow hospitals to accept the credentialing of another Joint Commission accredited hospital. There are a handful of telemedicine facilities that have obtained their Joint Commission accreditation, and they are required to adhere to the same credentialing standards as a hospital. Why do the proposed rules exclude JC accredited ambulatory care agencies and not allow the hospital where the telemedicine service is taking place to accept the credentialing information from the JC accredited telemedicine facility?
This is Jeannie. The regulation is specific to hospitals and critical access hospitals. Every provider and supplier type that receives Medicare and Medicaid funding has their own set of conditions of participation or conditions for coverage. We are only revising the hospital piece in the two hospital settings. This rule does not address any other setting, including radiology, the independent radiology groups, and so forth. Any physicians in those settings would need to go through the regular process that exists within the hospital, with the review by the medical staff and approval by the governing body. In addition, I wanted to point out, the proposed regulations do not say Joint Commission accredited hospitals. It says Medicare participating hospitals. So it's not based on the Joint Commission accreditation. It's a Medicare participating hospital. Communication between two Medicare participating hospitals.
Okay. Next question, and I might toss this to Dr. Raban, and then Jeannie, you can backfill, because this has to do with licensing, and I don't know. I'll toss it in the middle of the table, and whoever wants to respond can go at it.